Be ready? 5 seconds. Start. The information from the respondents stop. The appellant has neither made out a right under a statute nor any fiduciary relationship nor any right in equity by establishing that except by calling upon the defendants in the suit to render accounts, it is not possible for him to get relief. Stop. The appellant has sued for rupees 2 lakhs and paid court fee thereon. Stop. Nothing prevented him from suing for rupees 5 lakh 33,000. Stop. In para 5 of the plaintiff, he states that the total value of work done by him was rupees 10 lakh. Stop. He knew that he had been paid only rupees 4 lakh. Stop. He also knew the value of material supplied by the employer. Stop. In the circumstances, the prayer for rendition of accounts is not maintainable. Stop. The appellant next attempted to press into service section 149 of CPC to contend that he ought to have been given an opportunity to pay the deficit court fee on the total amount due for the work done. Stop. Section 149 provides that where the whole or any part of court fee prescribed for any document has not been paid, the court at any stage allow the person by whom such fee is payable to pay such court fee. Stop. Stanza. On an careful reading of the aforesaid paragraphs of the election petition contained in Annexure 1 of the writ petition, it is clear that election petition contains an adequate statement of all material facts on which the allegations of not only eligibility in counting of votes were founded, but specific allegations of manipulation and fraud played by returning officer while counting of votes were leveled with material particulars. Stop. Not only this, but the petitioner had also adduced voluminous evidence to support the allegations leveled in the election petition in respect of aforesaid illegalities and manipulations in counting of votes by entering himself in witness box and by examining his counting agent. Stop. The aforesaid version of election petition was also supported by other candidates by filing their affidavits before the election tribunal, which clearly established that the petitioner had adduced sufficient evidence affording a good ground for believing that manipulation was done and fraud was played while counting of votes by returning officer. Therefore, in my opinion, the only way to decide the dispute and to do complete justice between the parties was an order for recounting of votes. Stop. From perusal of impugned judgment and order passed by the election tribunal, it appears that the statement of petitioner and his agent in respect of manipulation in counting of votes has been rejected without any cogent reason. Stop. It appears that while dealing with issue, the election tribunal under wrong notion of law has illegally assumed that the petitioner was required to prove his allegations made in the election petition beyond reasonable doubt, whereas in view of legal position enunciated by Honorable Apex Court and this court from time to time as indicated herein before, such standard of proof for inspection of ballot papers for the purpose of recounting of votes is not at all necessary. Stop. The election petitioner was required merely to adduce such evidence on the basis of which allegations could be prima facie established, affording good ground for believing that there has been mistake or illegality or manipulation in counting of votes, and further on the basis of such evidence, court or tribunal trying the election petition could be prima facie satisfied for directing inspection of ballot papers or recounting of votes. Stop. A distinction between prima facie opinion and concluded opinion was required to be kept in mind, but while rejecting the prayer for recount of votes, in my opinion, the election tribunal has proceeded completely on wrong notion of law and rejected prayer for recount of votes on the ground that the petitioner has failed to prove his case. Stop. In this connection, it is to be noted that when the allegations in the petition were not vague or indefinite or frivolous, rather, they were very specific in terms and supported by oral evidence adduced before the election tribunal, inasmuch as affidavits of other candidates there was sufficient material before the election tribunal affording good ground to believe that illegality or manipulation was done in counting. Stop stanza. Sri Govind Saran, learned counsel for the petitioners, has submitted that the employee was not in service from 1986 to 1997. Stop. He filed the application after 11 years. Therefore, the question of his absorption regularization could not arise. Stop. It was not the case even of the applicant that he succeeded in the test conducted by the department, nor allegations of malafide had been alleged against any person, nor there was any pleading suggesting any illegality or irregularity in the screening test. Therefore, there was no occasion for the tribunal to draw the adverse interference against the department for not producing the policy. Stop. The tribunal could not issue a direction to absorb and regularize the service of the said applicant, as at the most the tribunal could direct to consider his case for regularization. Hence, the petition deserves to be allowed, setting aside the impugned judgment and orders. Stop. Sri Sanjay Kumar, learned counsel appearing for the respondent, employee, has submitted that it was an obligation on the part of the department to produce the entire record of selection before the tribunal, and as the department failed to do so, the tribunal has rightly drawn the adverse interference, and thus no interference is called for. Stop. The petition is liable to be dismissed. Stop. The question as to whether the service of certain employees appointed on ad hoc basis should be regularized relates to the condition of service. Stop. The power to prescribe the conditions of service can be exercised either by making rules under the proviso to Article 309 of the Constitution of India or any analogous provision, and in the absence of such rules, under the instructions issued in exercise of its executive power. Stop. The court comes into the picture only to ensure observance of fundamental rights and statutory provisions, rules, and other instructions, if any, governing the conditions of service. Stop. The main concern of the court in such matters is to ensure the rule of law and to see that the executive acts fairly and gives a fair deal to its employees, consistent with the requirements of Articles 14 and 16. Stop. It also means that the state should not exploit its employees, nor should it seek to take advantage of the happiness and misery of either the unemployed persons or the employees, as the case may be. Stop. As is often said, the state must be a model employer. Stop. It is for this reason it is held that equal pay must be given for equal work, which is indeed one of the directive principles of the Constitution. Stop. It is for this very reason it is held that a person should not be kept in a temporary or ad hoc status for long. Stop. A perusal of the authorities would show that appointments are as a rule to be made in accordance with statutory rules, giving equal opportunity to all the aspirants to apply for the posts and following the prevalent policy of reservation in favor of scheduled castes, scheduled tribes, and other backward classes. Stop. Whenever the employees are appointed on ad hoc. Stop. Over.